Okay, everyone, thank you for joining us today. Thank you for joining the Environmental Bankers Association EBA online webinar series. Today, we're going to be talking about the PFAS dilemma that's facing many lenders and real estate professionals across the country. We're here today to talk about PFAS. So what are PFAS? Per and polyfluoroalkyl substances. These compounds were discovered in the 1930s, somewhat accidentally, by Joseph H. Simmons, a chemical engineer who was a professor, and he was passing a dangerous fluorine gas through a carbon arc, yielding what are believed to be the very first fluorocarbons. Now, fluorine is the most reactive of all of the elements on Earth, and many chemists feared working with it. It's a highly corrosive, flammable gas that reacts violently with water to produce oxygen and the extremely corrosive hydrofluoric acid, which is capable of burning through glass, steel, copper, silver, gold, and even platinum. Simmons built specialized equipment to contain the explosion from the experimental synthesis, and even hired a former football player who he taught to run the process in his lab and escape before the blast destroyed. But that's not what happened. There was no explosion, no carbon tetrafluoride, which he was attempting to synthesize, just a few droplets of a clear, curious liquid. Ultimately, Simmons used mercury in the reaction to yield a new class of fluorocarbons. They were chemically inert and highly resistant to heat or environmental degradation. In 1940, Simmons was recruited into the Manhattan Project, where his fluorocarbons proved inert enough to withstand the corrosive effects of uranium hexafluoride and would be used in the development of sealants, gaskets, and pipes for the production of the very first atomic weapons, including the so-called Little Boy and Fat Man bombs that devastated Hiroshima and Nagasaki. Now these compounds are bringing a new kind of devastation to communities across the country. Today, Mark Westra and Mary Mendoza are here to educate us on PFAS risks that lenders are facing in a very dynamic regulatory environment, and offer guidance on how lenders can identify and manage their PFAS risk. Mark Westra is a principal at GZA GeoEnvironmental Incorporated and the Grand Rapids District Office Manager. He has a bachelor's degree of chemistry and pre-med from Grand Valley State and master's degree in environmental health and engineering from Northwestern University. Mr. Westra focuses his practice on pre-acquisition and pre-divestment environmental due diligence, as well as legal support and expert testimony. Mr. Westra leads multiple PFAS-related projects for GZA's clients within the Midwest. His environmental due diligence practice includes compliance with federal and state environmental property transfer laws. Mr. Westra is active on many ASTM international task groups related to property transactions and redevelopment. He currently chairs ASTM E5002 task group on PFAS implications pertaining to commercial real estate transactions. Mary Mendoza is a partner at Haynes and Boone, LLP, where she leads the firm's environmental practice group. Ms. Mendoza represents her clients managing environmental risks in corporate, real estate, and other transactions, as well as day-to-day compliance matters, enforcement actions, site cleanup, and toxic tort litigation. She has represented clients in transactions involving businesses engaged in the manufacture and distribution of PFAS, and recently has assisted clients in responding to state orders to investigate PFAS use and contamination. Ms. Mendoza frequently speaks and writes on environmental issues and is a former chair of the Environmental and Natural Resources Law section of the State Bar of Texas. I want to thank Mark and Mary for coming today to share their expertise with the Environmental Bankers Association. Following the presentation, we will have a question and answer session. Please submit your questions throughout the presentation using the questions tab and your control panel. And following the presentation, Barbara Rowling with Comerica Bank will be here to help us field the questions. So without anything further, thank you, and I'll turn it over to Mary.
This is Mary Mendoza, and first I want to thank the EBA and particularly Seth and Barbara for arranging the seminar, and thank everyone for joining us today. It's appropriate time to be having a webinar. As Sean talked about, PFAS is an emerging issue. Whether it's the next big environmental threat remains to be seen, but what is clear is that PFAS is the subject of intense regulatory, public, and litigation scrutiny. So the regulators and the courts are grappling with evolving information and evolving science on PFAS, And lenders similarly are left grappling with uncertainty over the risk that PFAS presents to their portfolios and how they address it. Our presentation today will start with an overview of what are PFAS, where they're used, how they impact humans through exposure, and then how PFAS is or may be covered in due diligence. We'll discuss some regulatory and legal risks associated with PFAS, and then close with a discussion of PFAS in your portfolio and what lenders can do or how they may want to address and manage this risk. And so now I'll turn it over to Mark to lead us off.
Great. Sean, Mary, thank you very much. I appreciate the opportunity to speak with everybody today. And I just want to quickly say we're going to run through a little bit of what are PFAS, what are their potential properties that make them unique, how are they similar to other things, and importantly, I don't want to presume that some of this information is going to affect our audience on their day-to-day underwriting decisions. But that said, I want to lay a little bit of a foundation now to be able to explain why we're going to be concerned about them or what unique challenges they pose when you're evaluating that transaction or portfolio. And so with that, as Sean mentioned, PFAS are a large family of man-made organic chemicals, but they're found every day throughout household use, manufacturing use, a whole host of very common products. And in particular, you see them in high performance applications, but that can be as simple as dental floss, or that could be a high performance coating for waterproofing. For instance, Gore-Tex and similar materials, the breathable waterproof fabrics. And I think the ubiquitous that we're probably all inadvertently exposed to every day is the food containers. So-called wax paper is really PFAS coated material, either cardboard or paper at this point. And why then are we concerned about them? If they're everywhere and we're exposed to them all the time, why do we care? And the biggest answer to that is they don't readily decompose. And if they don't decompose, that means they tend to accumulate over time. And therefore, that means both in the environment and the body. And the concern is always from a toxicological perspective, how long the body is exposed to a substance helps assess how toxic it might be. And with that lead in, the probably first comprehensive health study of PFAS was done as a result of litigation settlement that Mary will discuss a little bit longer for workers and community members exposed to PFOA near Parkersburg, West Virginia, the so-called C8 study. And the C8 study identified a link between PFOA exposure and 6 adverse health outcomes. But that is only an association. No causal relationship is established. It's simply that if, in fact, you are believed to have been exposed to more PFOA, then you are also more likely to have those 6 adverse outcomes. And continuing on in the drone of our PFAS abbreviated chemistry, the next topic I wanted to discuss is long chain versus short chain PFAS. As Sean mentioned, productions really ramped up during World War II. And from that time period through the late 1990s, early 2000s, the overwhelming majority of production and use worldwide were the so-called long chain PFAS. And It's a little bit arbitrary, but typically we consider PFAS with 6 carbons or more to be long-chained, and those were phased out in late 1990s, early 2000, and replaced with so-called shorter chain, the euphemistically C5 and shorter carbon chains. And the reason industry moved away from those longer chained compounds was the accumulation, that they tend to half-lives, human half-lives for the longer chain compounds tend to be in the single-digit year range for the long chain compounds versus the week to month range for the shorter chain compounds. And while it's not determined at this point, that makes them safer. The assumption is the shorter exposure, the more likely they are to be less toxic. Similarly, I want to talk briefly about the difference between the linear and the branch-chained PFAS. And this is clearly one of those cases that it's not going to affect portfolio analysis today or in the next 10 years. But it leads to a caution I want to make, and that's discouraging the use of total PFAS reporting and interpreting test results. And the reason for that is only a handful of PFAS compounds are currently quantitated in both their branched and linear isomers. And why that's important is the current methods require the laboratories that each time a new branched chemical standard becomes available, they must validate it and make use. So we've already seen this in a small number of cases. We expect to see it a lot more in the future as more branched standards become available. More PFAS will be found in samples, and that doesn't necessarily mean a change in the environmental conditions. It's simply a change in the underlying lab reporting. And so with that, now move a little bit to the application of where are we and quickly how did we get here. Importantly, EPA has not issued any enforceable drinking water or exposure criteria to any of the PFAS to date. Therefore, we've seen the states take the lead in enforceable criteria, while we've also seen EPA issuing health advisories and other guidance numbers. Throughout the last 15 years in particular, we see a consistent trend, and that trend is those guidance and regulatory values are consistently being adjusted downward. And the reason for that are multiple, some of which is increased knowledge coming out of additional study, but others appears to be a move by the regulators to use more conservative assumptions about PFAS exposure and their resulting toxic effects. And at this point, I just want to step back and remind everybody that PFAS concentrations are usually reported in parts per trillion. And when I was breaking in the business and in an environmental lab in 1980, we were awfully happy to be able to report concentrations of most environmentally significant materials to, say, single-digit parts per million levels, or a million times more than this parts per trillion. You see a couple of analogies to what is a part per trillion up on the screen. And I emphasize, just take a deep breath and ponder what is that 1 second in 320 centuries, and understand it's those orders of magnitude that we're reporting these results in. Incredibly small, even compared to the progression from parts per million to parts per billion, and now parts per trillion level concentrations. And with that, talking about a few of the special properties of PFAS, I now want to turn to a couple of analogies that we may or may not have been here before. Again, back in the mid to late 70s, we thought PCBs in the environment were stable, that they never degraded. Similarly, PCE, the common dry cleaning solvent, or TCE, its breakdown product, and also an industrial degreasing solvent. We thought these were stable in the environment and that they never broke down. Yet by the early 1980s, with some groundbreaking work out of Stanford and other research groups, we identified, but they do break down in the environment. And I'm certainly not going to sit here and say that will happen with PFAS, although there's preliminary indication from at least one published study that suggests at least some of these PFAS materials are in fact breaking down in the environment. So the jury's out. Are these the forever chemicals, or in 30 years will we be viewing PFAS the same way we today view PCE? The key to the portfolio evaluation that we want to focus on today is a little bit of how did we get here. The federal AAI rule promulgated under CERCLA for our landowner liability protections and the parallel ASTM Phase 1 standard practice are both keyed into definitions, the definition in particular of CERCLA hazardous substance. Poses a dilemma right from the get-go, however, because currently no PFAS are designated as CERCLA hazardous substance. So right away, I asked the question, is it possible then for a release of PFAS on the property to be an REC? That's something we need to ponder a little bit. In addition to that, it gets a little more complicated. I'm going to pick on my home state of Michigan here for a moment and contrast that with federal regulation. Under CERCLA, the refined petroleum exemption suggests that I don't need to consider releases of refined petroleum products in an AAI compliant assessment. Michigan, however, has no such exemption, so consistent with the Phase 1 standard, which addresses both the CERCLA hazardous substances as well as refined petroleum products, Michigan aligns then very closely with the ASTM standard. However, we go back to that CERCLA hazardous substance list. As we said, it doesn't include any PFAS. Michigan, on the other hand, in our mini Superfund statute, does define two specific PFOA, PFOA and PFAS, as hazardous substances, similar that 1,4-dioxane, another emerging contaminant nationwide, has been a Michigan hazardous substance for as long as I can remember. So as you can see, the layers of complexity just keep building. Differences between state and federal regulation, further differences between the states themselves. Again, digging a little deeper for Michigan, we had established that 2 PFAS compounds are in fact state hazardous substances. They have cleanup criteria. Michigan is in the final throes of rulemaking to propose MCLs for several PFAS, and we require notification for discharge of AFFF PFAS products. Contrast that to Maine, where PFAS are not hazardous substances under their mini Superfund law, yet they have established both cleanup guidelines and health advisories for drinking water. Furthermore, Maine requires notification of discharge for all PFAS to the environment. So you can see how this compounding differences between federal law, state law, and among the states themselves creates a patch quilt of issues and problems for both the practitioners, we the environmental professionals, and you, the lending community and risk management staff. So I'll repeat the question: can the presence of PFAS be a wreck? And as Sean mentioned, I am currently chairing a task group that will help provide guidance to both the environmental profession and the user community. That being said, that guidance won't be available until at least 2021. And so hopefully Mary and I can continue today to provide you some insight for what's coming. But again, I'm going to step back. Have we been here before? And I'm going to argue in a way we have. Hopefully many people in the audience are old enough, and hopefully many people are young enough not to remember the use of MTBE, the widespread octane enhancer used particularly near the two coasts back in the late 80s, early 1990s. MTBE wasn't a CERCLA hazardous substance when it was in widespread use, and in fact still isn't today. I mentioned a moment ago about 1,4-dioxane, a widely used product, a stabilizer in chlorinated solvents, also used as a precursor for many cleaning and personal care products. Not a CERCLA hazardous substance, but another emerging contaminant today. And do we see any alignment? An associate of mine was able to find these great comparisons between MTBE releases and use in the early 1990s and compare that to PFAS releases in use that was assembled earlier this year. As you can see, significant use of both materials countrywide, yet MTBE kind of faded in the background, and the jury's still out. What path are we on with the PFAS? And so with that, I'd like to turn it over to Mary and ask her to continue the discussions from the more legal perspective.
Thanks, Mark. Where do your borrowers, and by extension, you as the lender, face the risk for PFAS? And there are two sort of broad categories. There's a regulatory risk at the federal and state level, and then the common law or the litigation type risk. The regulatory risk, we've all seen this, and I'm going to talk about that in some more detail. And then the litigation risk, it's a huge range of claims. It may be regulatory claims, it may be enforcement actions, or it can be the traditional common law causes of action brought by private parties, the state. It's trespass, nuisance, negligence, failure to warn. So, see if I can make this advance, which... Sorry, I'm having just a little advancing problem. Mark, if you want to drive it and put it back to maybe slide 18.
Yep.
Thanks. So the regulatory costs, though, of PFAS can be immense. I mean, there's certainly the cost of compliance. And this could include cost of retooling a process to account for restrictions on use, as more regulations are put on PFAS, where it can be used, what PFAS can be used. Or it could include the cost, and I think Mark has some experience with this, to install really costly treatment systems for wastewaters that may have PFAS in them. You could have certainly the typical cost of non-compliance with whatever regulations there may be around PFAS, administrative, civil, criminal penalties. You could have costs of investigation and remediation, and then natural resource damages claims, which are always huge when they hit. And then you could have pretty significant common law liabilities, bodily injury, property damage, medical monitoring type claims, even stigma damages. So moving on to, at the federal level, as Mark was saying, there's really not a standard out there. What you do have is EPA has a PFAS action plan where they're proposing to regulate a couple of PFAS compounds under the Safe Drinking Water Act. They have made some interim recommendations for addressing groundwater with a screening level and a preliminary remediation goal, but they don't have an MCL. They've considered identifying both PFAS and PFOA as hazardous substances, and the U.S. House passed legislation doing so, but it hasn't passed the Senate. And then they have added certain PFAS compounds to the toxic release inventory reporting requirements. And at the federal level, they've been taking some enforcement actions. You see regulators being creative in how they're addressing this. They want to address it. They see the shortcomings in their own regulations. They've done TSCA actions. An interesting case, this last bullet point refers to a site that Mark is familiar with, a Wolverine site, where in western Michigan a CERCLA order was issued, and it ended up, I think, leveraging their CERCLA authority to address PFAS. Correct, Mark?
It did. They issued the order to remove or investigate CERCLA hazardous substances, but they really did that in response to public concern about PFAS. The sites had laid dormant for some time and actually had been through the CERCLA preliminary assessment process, deferred for state action, and then after the PFAS concern was raised, EPA came in and issued a CERCLA unilateral order to assess and in some cases actually remove CERCLA hazardous substances that happen to be associated with the PFAS sites.
So a lot of creativity, even in the face of sort of some shortcomings at the federal level. But really where that has left it, and Mark alluded to this, is it's really all in the states at the moment. You have a patchwork of state regulations and state standards. Some states have standards for groundwater. Some states have standards for drinking water, some for surface water, some for all three or two of the three, and some have no standards at all. And, this makes it hard to say I have a uniform policy of what I'm doing. But it also makes it hard to say on any particular site what it's going to take to clean it up. Several years back, I worked on a site for a manufacturer of a firefighting foam, which is notorious for PFAS. And we went into the state cleanup program, and there were no standards. And that resulted in a huge amount of cost because we were doing a lot of very basic science to develop standards. Texas now has some as a result of that particular cleanup. California, as you might imagine, may be somewhat at the is pushing the envelope on this. They did add some PFAS compounds to their Prop 65 list with a duty to warn starting a couple of years back, and then a duty not to discharge into drinking water beginning last year. The California State Water Resources Control Board has issued orders to several classes of facilities with decent PFAS risk, that may have used them based on the type of business or type of activity, and they've seeking information on what their PFAS use is and ordering them to submit work plans to conduct PFAS testing. Then, so moving on from the regulations, you move over into the litigation, and there's a lot of activity on the litigation. There have been a lot of common law suits brought, very traditional, personal injury, property damage kind of suits. A lot of several imminent and substantial endangerment suits, where suits are being brought under RCRA's imminent and substantial endangerment provisions, seeking an injunction to force a cleanup. But you also see a lot of very interesting failure to warn, product liability cases, people that used firefighting foam, bringing causes of action against the manufacturers of it. You also see a lot of interesting relief that's being asked for in these suits. The scientific panel that Mark alluded to on the West Virginia suit, which was out of a manufacturing of PFAS, and if you've seen the movie Dark Waters, you're familiar with this. But part of the remedy, part of the settlement in that was a massive scientific panel study that looked at links between diseases in the community and PFAS. And so you also see, requests for alternate sources of water, drinking water, or remediation of public water systems, all very expensive undertakings. And it's not just individuals now bringing these suits. It's states, municipalities, corporations suing other corporations over it. I just wanted to sort of toss in a couple of other, sort of some interesting things I've seen. On the Wolverine part that we were talking about, 3M was the manufacturer there, and they ultimately agreed to kick in some of the money to do some of this work around the PFAS. And a lot of commentators are talking about that the implication that 3M coming in and backstopping people that have used their product may result in plaintiffs broadening their litigation strategy, that plaintiffs' lawyers may be looking now at smaller companies that use PFAS, knowing that perhaps there's a bigger pot of money out there standing behind those companies. Now, the arrangement between 3M and Wolverine, I wasn't involved in that, and I'm sure that there were probably very specific contract terms that governed what 3M ultimately decided to do. But I think it raises a risk for maybe some smaller businesses that you might be lending to that have used PFAS along the way, that they might be a larger target than what you think for plaintiffs' lawyers. And then going on, Mark, I'll take it back to you to talk about where we see PFAS in commercial and industrial uses.
Great. Thank you, Mary. I think the obvious place we would start would be with chemical processing and chemical manufacturing, as you mentioned, the 3Ms, the DuPonts, now Chemours, that have long histories of manufacturing either the materials themselves or manufacturing with them. However, they're also used in a wider variety of the manufacturing setting, metal plating and anodizing, obviously particularly for high performance products like vehicles and aircraft, textiles, but a wide range of textiles, clothing, carpeting, anything where stain resistance or water repellent properties were desired. Similarly, we see them in other performance products, the water repellents, the Rain-X style products that you might apply, and therefore at commercial car washes. We see them in high performance floor wax and coating products, used retail, used in schools. And at least in one case I'm familiar with, we actually found PFOS in shallow groundwater underneath the former septic leach field of a school that we believe must have used PFOS-based floor wax. We've got no other explanation for why PFOS would be in that shallow groundwater near a former school. Another widespread concern is all this commercial and all this residential use of PFAS results in routine discharges to the municipal wastewater system. They, again, don't break down significantly. They may change chemical form somewhat, but breaking down to what appear to be stable end products, at least in this point in time. And those end products are either discharged to the surface water along with the remaining wastewater, or injected into groundwater if that's the discharge point. But importantly, they also partition and PFAS accumulate in the biosolids from the wastewater plant. In some cases, those biosolids are dewatered and landfilled along with other waste, but frequently, and particularly in the Midwest, those biosolids, in fact, are applied to agricultural fields for their fertilizer value and soil conditioners. And so
I'll have to say, chime in here for a second. When Mark was talking about this, when we were preparing for it, you know, you think back to how many times you read a phase 1 and see past agricultural use, and you don't really think anything of it. And this certainly maybe makes you rethink that particular decision.
Right. Thank you, Mary. I mean, we have, and again, this is unfortunately something that varies by community or state by state. In Michigan, we have pretty good records of land application of biosolids from the municipal wastewater treatment plants, but much less so or harder to trace records from any private treatment plants. Therefore, in some cases, there just may not be records available, no matter how diligent the phase 1 consultant is, in order to identify these concerns. And so we talk about, what about PFAS in your portfolio? But the concern doesn't stop there. PFAS are very mobile in the environment, much like the MTBE analogy I used earlier. And therefore, we do need to worry about migration. Something as simple as migration from the nearby septic system to migration resulting from that surface application and then leaching of PFAS from biosolids, use of AFFF firefighting foam, even airborne deposition of these materials, particularly downwind of manufacturers or large users, can be a concern. I mentioned a moment ago the municipal and industrial wastewater dischargers. All these adding to the environment and to the background, but also to the potential concern for any given transaction.
And Mark, I just wanted to ask you, oh, okay, here, I'm sorry, I was going to talk about your search radii, so.
Excellent, thanks, Mary. So here we have a scenario of what can lenders do to help manage this risk from the PFAS. And it does become the decisions. The largest search radius we have in the ASTM standard is 1 mile, and that applies to just 2 of the database listings, the NPL sites themselves, along with the RCRA corrective action sites. A much more common search distance with underground storage tanks, and usually the petroleum, is a half mile. These are very conservative when you look at prior studies that were done in the mid-2000s that suggested the 90th percentile of chlorinated solvent plumes in groundwater is about 1/3 of a mile. Similarly, the 90th percentile of that distance for petroleum plumes was down around 1/10 of a mile. Yet, personally, I've worked on PFAS plumes, multiple of which are over a mile in length. Given that mobility, given those standard search distances, how does the lender address this? Do you want to ask your consultant to do broader, more comprehensive searches? If you do, though, what do we look for? As we said, the PFAS site may not be the NPL site at this point. Mary, would you like to take us through this point?
Well, yeah, and I think that, the other, it is a real decision about, what do you decide to tell your consultant to expand the, not only the search radius, but also just the scope of the phase one to include PFAS as a risk. I mean, it is very much a transaction-specific consideration. I think the first thing is, what's happening in the state where the property is. Some states very much regulate it, and that may push you much more toward looking at it. What type of property do you have? Is it a manufacturer where you have a risk from the actual on-site use? I've done many transactions recently where the people that were looking at the purchase of the facilities, their consultants, as a matter of course, were asking about PFAS. I mean, it was a manufacturing facility, so it certainly had a larger risk, but people were definitely looking at it. I think more people are adding it into their list of questions that they at least ask about the history, about what about what chemicals were used on site to make a decision. Or is the real PFAS risk from off-site uses? Is it the surrounding properties? And Mark, do you want to talk some about the type of transaction? Or?
Sure, I'd be happy to, Mary. I mean, I think if I flip hats for a moment and I'm in the, reviewer, the risk management role for the bank and sort of my normal provider role, I'd be considering multiple things as Mary mentioned, state by state. What's the regulatory scenario, the history of my property, the obvious office building versus former metal plater, for instance. But also then, where am I? An original loan. If I don't have any exposure to the property, do I want to be a little more conservative up front? Similarly, in the renewal process, do I want to dig for skeletons in the closet of the property that I already have as collateral? And finally, another unique scenario is foreclosure. Do I want to dig a little deeper in the foreclosure process in the anticipation that that's what the next person may do? I mean, obviously, the unfortunate scenario of foreclosing on the property, the next thing I'm hoping to do is get it right back out of my REO portfolio. And so with that, I think we'll entertain questions if we have some.
Yeah, thank you. Barbara Rowling is going to be, with Comerica, is going to be fielding your questions. So if you just go to the questions box in the control panel, feel free to type in a question. But Barbara, I understand we have a couple questions already.
Yeah, one that came in was a question about the manufacturing operations. It just seems a bit overwhelming to consider what if it's a pizza box manufacturer, which seems a bit benign, but if you think about there may be a coating on that pizza box, I guess the question that was asked was, is there going to need to be a different depth and level of sophistication on the consultant's part when they're doing the due diligence to understand where these PFASs may have come into their manufacturing operations, since it seems to be ubiquitous? Or if it's a dental floss manufacturer, like in the slide, most people don't think that PFAS is in dental floss. So does that need to be part of the standard dialogue, or like it was mentioned earlier, it's something that is an extra scope that needs to be discussed with a consultant?
Well, I'll start on part of your question, Barbara, which is, I think it definitely, you want to make sure that your consultant that you're using for this is up on what's happening in the world of PFAS, that they have familiarity with it, and perhaps that they have a decent amount of familiarity with the type of industry that's involved in the property that you're lending on. Because you can't even have the dialogue with them about whether you need to expand your scope if they're not able to give you sort of some rough idea of how big of a risk it is for that kind of industry.
And if it's okay, Barbara, I'll pick up where Mary left off on that. And back to the pizza box example, I think the answer depends how far we go back upstream. If in fact it is just the box board cutter and assembler of that pizza box, they're going to be primarily die cutting and folding an already prepared set of products. On the other hand, if in fact it's the box board manufacturer themselves that are coating that cardboard or coating that corrugated media at the bottom, that's holding the pizza, that would prove, in my mind, a much higher risk than, say, the company that is simply doing the die cutting and folding.
Okay, thanks for the answer. There's another question that has been submitted. For a bank ordering phase ones, do you think that a bank that does not specify PFAS as part of their scope of work will be held liable in the future for this omission?
That it's a good question. I don't think that PFAS at this point is just, it's absolutely in everybody's scope, so excluding it is a problem. But on the other hand, I think, a prudent bank, prudent agent would make sure that there is some consideration of whether the scope needs to be expanded. It's an evolving standard. It's an evolving issue, and so the downside to it is that it's always going to be looked at with 20/20 hindsight. It will never come up if the loan's repaid successfully, or it will never come up if you manage to sell it and somebody buys it after a foreclosure and there's never any claim around it. But when it does come up, certainly somebody will be saying, oh, well, you should have known about it at that time. And it's getting a lot more attention. So, looking at what the standards are that are out there, I think is very important. Talking to your consultants and discussing with them whether there is a rationale or a reason to broaden the scope on any particular transaction is probably the prudent course right now. I know Mark, I think, though, has been working on some of the ASTM standards, and that can also be something that helps lenders know where they need to be headed.
That actually ties into the next question, which is, Mark, where do you see the new ASTM standard going with regard to PFAS?
I don't see the standard deviating, frankly, from where it is now. that the standard was designed solely around the CERCLA hazardous substances, and because of their widespread use and the absence among the states to follow the federal lead for the petroleum exemption, I see the phase 1 standard following that course, that there's no change. What I do believe we're going to see, and what my task group's working closely with the phase 1 task group, is to try to get some guidance and clarification to help people along the way. For instance, since first drafted, the phase 1 standard has recognized the fact that state and local laws can deviate from federal law. And we gave multiple examples of that earlier. That opens up the door for practitioners. Does a user request, and therefore does the practitioner make a deviation from the standard to consider the state's definition of hazardous substances in addition to the federal definition? If you do, then you've opened the door and you're performing an ASTM compliant phase 1 assessment, even though you've deviated from the standard. You're fine as long as you document that deviation, in my opinion.
We have another question regarding if a bank is selling a piece of property and the buyer requests testing the site for PFASs. What do you recommend?
This is Marion. I mean, I'm always, if the bank already owns it, and I am very reluctant to allow testing absent some really compelling reason to do so. I hope it doesn't become this situation that PFAS doesn't turn into something where people just always want to be looking. So, absent some really compelling reason where the bank finally assesses that they'll never manage to sell it without doing something like this, I would not want to go out and start looking.
As far as cleanup and remedial methods, what do you typically see, and do you have ranges of costs for cleanup of this?
Unfortunately, at this point, Barbara, the cleanup technologies are pretty limited. For soils, really what we've seen by and large actually used out in the field are good old excavate and transport to disposal facilities if they'll actually accept PFAS-based waste, which is fewer and fewer, certainly in the Midwest, which, as we know, is essentially a shell game. We're just moving the PFAS from one point to another. Hopefully it'll stay there longer, but nevertheless is the shell game. For soil, the other technology we're seeing is ex situ incineration. Both of these technologies are relatively expensive. They're certainly not environmentally friendly from the sustainability standpoint, with CO2 emissions during excavation, during transport, and during incineration, for instance. But those are the two that we're typically seeing as treatment technologies for the soil. For groundwater, or as Mary mentioned, wastewater, we're seeing primarily two technologies at this point that are really variations of the same thing, either carbon adsorption or ion exchange, which again is somewhat of a shell game. It's grabbing the PFAS from the wastewater stream and immobilizing it onto the solid. But now you're back to the soil analogy. What do I do with that PFAS containing solid, the carbon or the ion exchange resin? And again, landfill disposal and incineration are probably the two most common, although at least with activated carbon, for some uses, we are able to regenerate and reuse that carbon for additional treatment. The costs vary significantly with the waste stream, but can be expensive. It's just tipping fees that we're seeing in the Midwest for landfilling PFAS containing solids can be over $100 a ton at the gate.
We received another question going back to the prior question, which had to do with a potential buyer for a bank-owned property and flipping it to a new loan from the bank. Does the bank want to know before our buyer wants to purchase the property what they're buying and what we're collateralizing?
So I want to make sure. So this is somebody's just going out and buying something. The bank doesn't have anything to do with it.
That's correct.
I still think. I mean, I'm still not philosophically. I am still not a proponent of testing just because you can run a test. I think there needs to be some real indicator of why you need to be running a test. You know, I'll have to say I've worked on a site that it was contaminated with one particular chemical. It was a plating facility. It was contaminated with a chemical from that. Turns out now they did have a PFAS compound out there as a fume suppressant. I would probably say test for PFAS if I were buying, definitely, because if the chrome leaks, the PFAS probably leaked right along with it, perhaps. But if I were buying, you know, something that's relatively benign or that doesn't have a definite indicator, I'm not sure I'd test. I don't know, Mark, what you're seeing clients do, but I don't think I'm still not seeing people just go out and test just because.
No, I think that's right, Mary. I think it would be no different at this point than other hazardous substances or the petroleum products. The question is there a reason to believe they or likely was a release, or there's known to have been a release in your chrome plating example to trigger some form of testing?
And the one other reason, I'm just going to toss this out quickly on, do you test, do you not test, do you want to know, do you not? Insurance can play into this, and this may be not quite as much of an issue for a lender, but it may be for your borrower. You know, if you have a borrower who has a pollution that routinely buys pollution legal liability policies for their activities, and I've got some clients that do routinely do that, manufacturing clients. You know, whether they know about something or not really impacts whether the policy covers it. And many policies exclude voluntary testing as well. So, you know, we think about that. When I'm representing the borrower, and we do think hard about, do we voluntarily test for anything? Just simply because the policy, if we have a policy in place and we already own the property or lease it, we may be giving up our insurance coverage if we voluntarily test. But I will also say you are seeing some insurance companies starting to put some PFAS specific exclusions in. So it'll be interesting to see how widespread that becomes.
Well, that's our list of questions that I'm seeing so far, unless there's any others out there.
Well, we've been going for just about an hour as well, so I want to jump in here and thank both Mark and Mary, and especially Barbara Rowling, who helped organize this, for this wonderful presentation. Clearly, they've given us a lot to think about here today. Lenders have decisions to make. Are we going to stick our heads in the sand and wait for the federal government to declare PFAS a surplus hazardous substance? Or be proactive in identifying these risks in our portfolios. And I think clearly each lender is going to have their own risk tolerance, their own take on it. But thank everyone for joining us here today, and we look forward to seeing you at our next webinar. That webinar is going to be, I believe, on May 7th, and it's going to be regarding foreclosures and the anticipated rise in foreclosures and how to manage due diligence in that environment. Thank you, everyone.